We'll just wait for them to go ahead. It's sharp 4 p.m. now. Can we start, CIA? I think quite a lot of logging in right now. I think he's waiting. Good afternoon, ladies and gentlemen. Gives us immense pleasure to host this webinar on behalf of the India International Arbitration Center, which has been recently established by an act of parliament in India and declared as an institution of national importance. My name is Ganesh Chandru. I am a member appointed under the Act, the India International Arbitration Center Act. And it's a great honor to have an esteemed panel here and be part of the India ADR Week 2023 that's been put together by the Mumbai Center for International Arbitration. On behalf of IIAC, I wish to thank MCIA and Ms. Niti Sachdeva, the Registrar Secretary General, for inviting us to be part of this great week. There are excellent events happening in India this week in Bangalore, Mumbai, and from tomorrow in Delhi as well. This is a virtual conference, as you all know, and it's extremely heartening to see several participants who have logged in from all across the globe. My name is Ganesh. As I said, I practice international arbitration, and I wear another hat and I'm part of a law firm, Dua Associates, and I am also a member here with the IIAC as a part-time member, I should say. And the topic we thought was a very important topic in the Indian context. And, as you can see, the topic is moving from ad hoc to institutional arbitration, need for a paradigm shift in approach. So, as you all know, ladies and gentlemen, India is a seat for arbitration. We follow the common law system in India. We follow the British common law system. And ad hoc arbitration has been the practice here from time immemorial, at least the modern legal system. India followed the the English Arbitration Act, and then we had the 1940 Act, which is also modeled on the English Act. Then India adopted the Ancestral Model Law in 1996, and then we have the Arbitration Conciliation Act now. And recently, there's a Mediation Act, which has just been received as sent to the President last month. And now that part in the Arbitration Conciliation Act that deals with conciliation has been subsumed into the Mediation Act. So there are a lot of interesting developments that happen in India. But traditionally, we've been having ad hoc arbitration. That's because we've been following the British common law system, and this is what traditionally common law countries were used to. But definitely in the last, I would say, 20 years, there's been a great move towards and a push towards institutional arbitration. In fact, the government has taken a lot of steps, and among many other steps, the establishment of the IIAC is one of those steps where they're supported by the government, but this is a completely independent and impartial institution. Just the initial push is given by the government. So, with that background, with a seat where ad hoc is prevalent, establishment of a lot of institutions, Mumbai Center has been doing an excellent job in Mumbai. We have the Indian Council of Arbitration, which has been there for many decades now, headquartered in Delhi. And in Chennai, we have the Nani Palkiwala Arbitration Center. In Hyderabad as well, there's the International Arbitration Mediation Center that has been established. So there are these centers in major metropolis in India today. And these are all still, I would say, at nascent stage. Though ICA, Indian Council of Arbitration, has been there for many decades. If you look at the institutions which are much newer, I think institutional arbitration, in my view, is still very nascent in India. And parties typically choose London or Singapore for international arbitration when we go outside of India. And this has been the practice till now. Institutional arbitration is there, but considering the big pie of Indian arbitration, I would say it's an extremely small percentage. Probably I would put it at not more than 2 to 5% of institutional arbitration happening in India. Even that is a very, I wouldn't say that it would be even 5%. Most of the arbitrations that we do, are in fact seated in India are ad hoc arbitration. So with that background and considering that, we have followed the English common law tradition, I would like to first move to Charles. But before that, may I have the pleasure of, introducing all the three speakers at one go. And then we will have, individual, questions for each of them. Charles is a barrister at law. He's a King's Counsel and practices from Fountain Court Chambers in London. He was called to the bar in 1986, and he took silk about 20 years back. And he practices a wide variety. Commercial litigation. He appears in the Commercial Court, in the Chancery Division of the High Court, and appeal at all levels. And he's a sought-after counsel for international arbitration, and he does quite a lot of offshore work. Charles perhaps was an Indian in his previous birth because India is not new to him. He travels to India quite often. And, he was, in fact, the founding chair of the Commercial Bar Association of England and Wales's India Committee. And, which seeks to enhance the connection between the legal professions in both these jurisdictions. He has regularly spoken at conferences in India. When not at work, Charles, attempts to play in a jazz band, but he's not yet ready to give up his day job. So with that, welcome Charles on board. And great to have you here. And, we hope to see you more often in India. Moving on to Ian Schaefer, leads King & Spalding's international commercial arbitration practice in Germany. He heads the firm's German dispute resolution practice. He acts as a counsel in commercial and investment state arbitration. He also sits as an arbitrator, both in domestic and in international arbitration. Ian, as like Charles, is also not new to Asia. He spent a good 2 years in Singapore and did his master's, an LLM program from the National University of Singapore. He was, I recall, a Rotary Scholar, and he did a great job on comparative law, Asian arbitration law, in fact, focusing on interim measures of protection. And he compared a lot of institutions in Asia with international institutions, and his thesis is something which I think at some point he should publish it and update it. And he was also a Gillis Vetter Prize winner for his article that was published in one of the top journals. He's a board member of the German Arbitration Institute. All legal directories count him among Germany's leading arbitration lawyers. Welcome on board, Jan, and it's great to have you here today. Yeah. Moving on to Ashish Chugh. In fact, it's heartening that Ashish is here because the India International Arbitration Center is headquartered in Delhi, and Ashish started his practice in this very jurisdiction. He's a Supreme Court lawyer in India. He is currently a principal at the dispute resolution practice of Baker and McKenzie in Singapore. And in addition to India, he's also qualified to practice in England, New York, and Singapore. He is a fellow of the Chartered Institute of Arbitrators and has broad experience in the conduct of international arbitration with seats in all possible major seats, including Singapore, Dubai, Hong Kong, India, Kuala Lumpur, London, and of course, Delhi, and a variety of institutional rules and as well as ad hoc arbitration. Ashish has acted as counsel in a number of international arbitration with respect to commercial disputes, and his specialty, among other things, are technology, telecom, and joint ventures, as well as a wide range of industries, including aviation, commodities, energy, investment, funds, power, and shipping. He is recognized again as a key practitioner in area of international arbitration in Singapore by various legal directories. With that introduction of this stellar panel, I open up, my questions, as I may put it, to all the to the panelists here. I was giving an introduction about India and India's legal heritage, how we followed the common law, English common law tradition. Now, Charles, with that background of how India, the close connection between India and England, and several India parties choosing London as a seat of arbitration, in addition, of course, to Singapore in recent years, can you give a historical perspective of how arbitration developed in the UK, especially in London? And I would also like to know whether the establishment of the London Court of International Arbitration has encouraged more parties to adopt institutional arbitration as opposed to ad hoc? Or is there anything else you wish to draw our attention to in terms of the arbitration landscape in London?
Okay, well, Ganesh, great pleasure to be here. Good morning, everybody listening from here in London. I'm extremely sorry that I can't be out in India for the ADR week. I was in Mumbai only last month, and I had my usual feeling on return, which is that everything seems a little bit grey over here compared with how it is when I come back from India. Anyway, the history of arbitration in England, I'm going to talk about England rather than the UK, goes back obviously many centuries. And as you know, Ganesh, the English love their clubs. That's one of the things that we're sort of known for. I was reminded of that when I went to the Bombay Yacht Club a few weeks ago. And historically, a lot of arbitration, particularly around the City of London, would have taken place, and still does, through what we would have called in medieval times guilds, through trade associations, which I think one could say represented a sort of basic institutional framework. They might not have had particular rules, they certainly wouldn't have done centuries ago, but there would have been a fairly fixed practice of how arbitrations were conducted, and the courts, particularly after Lord Mansfield in the 18th century, gave that support and let them get on with it. In terms of more formal arbitration institutions, as opposed to shipping, particular trades, insurance, and so on, those sectoral specific mechanisms. At the end of the 19th century, the London Chamber of Arbitration was set up, which is now the LCIA, with a sort of quite a big fanfare to try and compete with the court system, which, even though it was itself being reformed, was perceived as being too slow, too expensive, and having decisions made by judges rather than by business people. Has to be said that the real turning point in more modern times was what happened in the 1980s, when we had a very distinguished judge called Sir Michael Kerr, Lord Justice Kerr, who retired from the Court of Appeal. He's actually, for those interested in trivia, was the brother of the writer Judith Kerr, who wrote a children's book called When Hitler Stole Pink Rabbit, which is very known. Anyway, very distinguished family, and he took over the LCIA on his retirement and really sort of modernized it and brought it into shape. And so what we've ended up with in terms of the domestic institutions is, in a rough sense, the LCIA sitting at the top and handling, from an institutional point of view, quite a significant volume of large-scale commercial disputes. And if you're talking about people writing institutions into their contracts in advance, then as far as from an English lawyer's perspective, you're primarily looking at the LCIA or the ICC as the options which people put into their contracts. The reasons why they do that, I don't know if that's something that you want me to talk about now, or if it's something you're going to come on to later, Ganesh. But there are quite a few significant reasons, I think, why people choose to go down that road. It's not directly to do with the differences in court supervision, because fundamentally the legal framework that we have is the same for all arbitrations, and there's no discrimination between different types of arbitration. But I think there are significant reasons of practicality. The first one's probably in the appointment process, because once you're in an institutional framework, and I'm here talking about a full institutional arbitration, not simply applying, e.g. the UNCITRAL rules, but a proper institutional framework, then you know that you're going to get a quick appointment. And that's obviously very important, because a key feature of the arbitral process of getting your dispute resolved fairly quickly is something that can often go wrong right at the beginning otherwise. So people are keen, if they're well advised, and particularly, I think, if they can see that they might be the party claiming money, if you're the party providing services or something of that kind under a large contract. Very important to know that you can get the thing moving. And the institutional framework gives you that. So that efficiency is also carried through at the stage of the actual conduct of the reference. In London, at any rate, a lot of the local arbitrators who work through the LCIA are people, in a sense, like me, I suppose, senior members of the bar or former judges who've retired and are looking to supplement what they no doubt see as their meagre state pension by some arbitration fees. And it makes quite a big difference being able to deal with those people through an institutional framework. It just makes the actual administration of the arbitration a lot more efficient. It's, I guess you could say, a lot of people in my world are not particularly good at administration. It's not something that we've been trained to do. There's nothing in the life of a senior barrister or a judge which encourages you to sort of, do your own washing up, so to speak. So it helps those people to have a kind of nanny to look after them. They're best not left unsupervised, if I can put it in that way. And that does help. And then finally, at the end, there's a difference between the different institutions. Maybe that's something we can come on to later, which
I will certainly allude to that in a bit.
I thought.
But thank you for laying the. Yeah. So it's good to know. I mean, how ad hoc and institutional arbitration, especially the institution LCIA, how it has helped transform the mindset in London. And of course, you're also talking about ICC. I will specifically come to that, Charles, in a bit. But before that, as everybody here knows, many of you are arbitration practitioners, dispute resolution practitioners who are here, and you will all agree. I mean, you will all know. I mean, definitely know that for you to resolve your disputes via arbitration, you need to have an arbitration agreement, either in form of an arbitration clause in your contract, or you need to enter into an arbitration agreement after the dispute arises. So Ashish, getting the arbitration agreement is extremely paramount, isn't it? Especially these days, for example, by following a model clause proposed by institutions. However, there might be occasions where you can have an eventualities that can come up even if you have a good, you think you may have a good arbitration clause. Like, for example, the famous Anupam Mittal case saga that happened in Singapore recently, and also the repercussions it's had in India and, the Bombay High Court decision and all that, which involved an Indian company. Maybe you can settle, you tell us a little about that, and also in the context of an arbitration agreement, what's important. It'll be great if you can address this, and since you also appeared in that case, it'll be great if you can throw some light on that.
Thanks, Ganesh, and hello, everyone. I'm again, like Charles, I would have very much liked to be present today for the India ADR week, but unfortunately, I've just had another commitment and I have not been able to make it to India this time. But Ganesh, the question I think is very pertinent, and if I could just take a step back, just going back to Charles's point, really what we're dealing with when we talk about institutional arbitration is a change in mindset. And that mindset change happens in various different ways. One is the pure infrastructure, and Charles gave a nice historical account of that. But another is just how parties become a lot more sophisticated. I'll give you an example. Here we are struggling in India to figure out, what's the next step? How do we evolve from ad hoc to institutional arbitration? And that process has taken us a while. It's been ongoing, that whole debate, for a fairly long period of time. There are other countries that have gone about it completely the other way. So if you take, for example, China, their ad hoc arbitration from the get-go was forbidden. So it could only be institutional arbitration, and that's the only way that you can actually conduct an arbitration in mainland China. So you'll see that various countries have come up with their own ways in which they want to sort of tackle this problem. Now, for me, I think one of the clear indications of how parties become sophisticated is when they're able to streamline and institutionalize their whole arbitration framework. Now, one of the ways that you see it, and one indicative way, is with ad hoc arbitrations, there's usually no recommended clause, no model clause that parties can fall back on. And we've had sometimes very comically a number of pathological clauses, over the last 40, 50 years, which, people present in various case presentations. Now, I think that those days are probably behind us quite safely. And a large part of it is because of the advent of institutional arbitrations, where parties now have a lot more sophistication and they have a lot more tools in their armory in terms of the types of arbitration clauses that they should use. One particular area within arbitration clauses that I think still is quite nascent and controversial is whether you should have a law of the arbitration agreement. For most people, especially common lay people, it doesn't make any difference to them, right? What they're more interested in is just trying to make sure they have a substantive law, a governing law, and they know where the seat is. That's really what they're keen on. But it's a legal construct which has taken a life of its own, this whole law of the arbitration agreement issue. And I'll give you one case. Ganesh, you're right. I represented one of the parties in a Singapore Court of Appeal case recently, is Anupam Mittal versus Westbridge. And I think the facts are quite well known. Most people in India are quite familiar with it. But what gets people very aggrieved by everything around that particular decision is in India, people can't get their head around how it happened. Now, in India, I think people do realize that you have certain provisions of the Indian Companies Act, namely Section 441, 442, which essentially say that for oppression, mismanagement of Indian incorporated companies, the exclusive jurisdiction to raise those complaints is a body called the NCLT, the National Company Law Tribunal. And by statute, it has exclusive jurisdiction. And the statute actually goes on to say that those matters are not arbitrable. Now, you'll see a lot of joint venture agreements in India where the compromise that's struck is the parties decide the governing law will be Indian law, because that typically is the law where the performance is going to take place. And they say, well, see, let's go somewhere else. Let's go outside India for a number of reasons. And one of the popular jurisdictions tends to be Singapore, amongst others. Now, that is a very common way in which joint venture agreements have been negotiated for many years now. And one such case was this Anupam Mittal case, which ended up having a governing law as Indian law, and the seat being Singapore. Now, typically, if you go down that whole legal construct of a law of the arbitration agreement, you'd notice that one of the first indications that in order to ascertain what is the law of the arbitration agreement is the governing law. Why is this important? It's important because there are times when parties want to understand the validity of the arbitration agreement. If they can challenge a certain arbitrator, where can they do it? What is the number? What is the interpretation of the arbitration agreement? There are a host of reasons why this becomes an important issue. And in this particular case, you would ordinarily think, given that the governing law is Indian law, that the law of the arbitration agreement would be also Indian law. If that is the case, one could argue that all matters of oppression mismanagement, because they're not arbitrable under Indian law, therefore the parties could not have intended that to have actually been the case. Unfortunately, in this case, the parties did not have the great degree of sophistication or foresight to say that the law of the arbitration agreement would be Indian law. If they did, the outcome would have been completely different. And that goes back to my point of framework. Institutions actually help us provide that framework. You'll see a number of institutions now that recommend not only the governing law, but the seat, as well as the law of the arbitration agreement. Now, in this particular case, because the parties had not expressly set that out in their agreement, it gave the court flexibility to say, actually, in this particular case, the law of the arbitration agreement will be Singapore law, because if we chose Indian law, it would make the parties' claims to that extent under the arbitration agreement invalid. Now, again, that may not necessarily be the most satisfactory answer in a number of different jurisdictions. We sort of get that. But the point is that it's that degree of sophistication that parties need. And if they had the foresight to include this, it could have come to a point where they saved a lot of money by trying to arbitrate in Singapore, going to court for, let's say, an anti-suit injunction to restrain parties from pursuing claims at the NCLT, and they could have just got on with pursuing their claims at the NCLT if that was the express intention. So just a case on point, something that I think all of us should try and consider, that this helps us in various different ways, and institutions actually add a lot of value into the whole arbitral process.
Thank you, Ashish. This case quite interesting, and it's very important for parties, especially corporate lawyers, drafting their arbitration agreements in the contract to consult their partners or colleagues in the dispute resolution practice. Please don't just go by model clauses, because I don't think many model clauses include the law governing the arbitration agreement. And if they had the law governing the arbitration in this agreement in this case, I don't think it would have gone to the High Court and Court of Appeal. And the jurisdiction of the arbitrator would have been ousted, because under Indian law, this is not arbitrable, oppression and mismanagement. And I'm sure it's going to be a problem, and it's already a problem when it's come before the Indian courts. I mean, of course, that's a topic in itself. But the reason I asked Ashish to speak about this is, even if you have an institutional arbitration clause in your contract, things can come up like the one in the Anupam Mittal case, which happened in Singapore. So therefore, it's extremely important to get your arbitration agreement right. And especially, I think Charles mentioned about, ad hoc arbitration where you don't really follow clauses, or, whereas in institutional arbitration, you have the benefit of a model clause. In fact, now we are also coming up with a model clause where we will be introducing not just the usual things like substantive law of the contract and, the place of arbitration, but also the law governing the arbitration agreement. Now we have seen England position in England with Charles very, as an opening batsman, did a great job, and Ashish has now spoken about arbitration agreement. Now moving on to the place where really institutional arbitration is very much practiced. Ian, moving to continental Europe. I know you practice in Germany, but you do arbitrations all over Europe. How has it been over the years? How has the practice of arbitration been over the years? Is it mostly institutional, or there is ad hoc as well? And if it is institutional, can you let us know why this option has been preferred over ad hoc in continental Europe, especially from the angle of your German institute, as well as from the ICC's angle and Stockholm Chamber? There's some excellent institutions that you have. Can you just tell us about continental Europe and how it is, and the civil law system, how institutional arbitration has been a success story?
Yeah, thank you, Ganesh, and hello and good afternoon to everyone from Frankfurt. Well, if you talk about continental Europe, I think one needs to be similarly careful as if one speaks about Asia, because it's a very diverse club of jurisdictions out there with different legal traditions. So I think one thing is pretty much in common on the continent, and that is that we have a codification of civil procedural rules. And most of these codes, they came into effect in the 19th century. And you find some provisions on arbitration in there. That was the framework basically for ad hoc arbitration. If you look at institutional arbitration, in the last years, you've seen a couple of celebrations, 100 years. So I think the Stockholm Chamber of Commerce Arbitration Institute, they had their 100th years birthday a couple of years ago. The German Arbitration Institute 2 years ago, and this year is the big party of the International Chamber of Commerce, the ICC. So that's a rather new phenomenon if you think that arbitration itself goes back to the Roman days in continental Europe. What we know is the statistics of the arbitration institutions, how many cases they do every year. What's unknown is basically how many ad hoc arbitrations take place. And if you go through the different jurisdictions, of course, you can talk to practitioners, you have your own experiences, and it's very diverse. Let's just take the example of Germany. Construction arbitration is one of the key practices in some jurisdictions. In Germany, most of the domestic construction matters go to court. They don't end up in arbitration at all. What is the bread and butter business in arbitration in Germany is pretty much post-M&A arbitrations. If you have a business combination and the target company is in Germany, German substantive law applies. It's very common to put in an arbitration clause. And this type of work goes to the DIS, the German Arbitration Institute, institutional arbitration. But then there's also a large pocket of corporate disputes that go to ad hoc arbitration. So nobody really knows about it. And that's exactly what the people want. They don't want this even to be known in an institution. There are a lot of people involved in an institution. Even so everything is treated confidential, still a lot of people know about it. But if you have a really, really tricky corporate shareholder dispute or among the owners, you really don't want that to be known outside. So ad hoc arbitration in that area is still popular. It's basically done with arbitrators recruited from the Federal Supreme Court, retired judges, or it's professors. Whereas in the institutional arbitration field, like DIS arbitration, is pretty much attorneys. Often of them, they used to be M&A lawyers in the post-M&A space, so they know how to draft a contract, they know about the practices, they know about the commercial background. That's very popular. That's the German case. If you look to our neighbors, for instance, in the Netherlands, you see that construction arbitration is very, very popular. And they have an own institution just doing arbitration in the construction space. And if you look north to Norway, for instance, that's the jurisdiction where ad hoc arbitration is very, very prevailing, and you only have a very little institutional arbitration. So it's different from jurisdiction to jurisdiction, and it also differs within the type of dispute you're talking about. But commonly, when I recommend my clients as a counsel whether they should go for institutional or ad hoc arbitration, I usually say, well, go for institutional arbitration. It has certain advantages. And just to name 3 of them. The first thing is it's much easier to file your claim. Under the arbitration rules, it's you hand over your request to the institution and the arbitration commences. And that's an important legal point in time for time bar issues and other questions. Under the German arbitration law, an arbitration commences when you serve it to the opposing party. And service can be troubling. So you get away with all the headache if you just hand it over to the arbitration institution. The second thing is, if the other side doesn't appoint an arbitrator, and I think Charles already mentioned that, and you are ending up in a default situation, you need to go to the courts. And the courts are not necessarily those who really have a lot of knowledge about the arbitrators. So what likely will happen, you get a judge, a retired judge appointed that the judge knows. And in Germany, it's not like in England where you have barristers becoming judges, but it's more a career judge. So they start out and they are all the time in their judicial, in the court track. So they're not really necessarily commercially minded. They're very good lawyers, but not necessarily commercially minded. But in an arbitration, you might want to have somebody who also have some common commercial sense. And then, of course, the question is, if you have an ad hoc arbitration, you need to make an agreement with the arbitrators on their fees. And that's the point, something I really don't like to start talking about money with the arbitrators, because some of them, they're really commercially minded. And, you know, when they come up with their own ideas how they should be remunerated, sometimes you feel like, okay, I'm not really having full trust in these guys. They're very well self-serving when it comes to their fees. And you don't need to talk about money. If you have an institutional arbitration, it either goes by hourly rates or it goes by ad valorem schedules, and that really is an easy start of an arbitration. So that would be basically the 3 points I would always recommend to my clients. Say, rather go for institutional arbitration than for ad hoc arbitration. Of course, depending on the jurisdiction and the traditions, if you propose institutional arbitration in an area where ad hoc arbitration is prevailing, I think you probably have a hard time to convince your opposing party to accept that. But if you know the landscape and you know what's prevailing and what type of disputes, I think you can always find a good solution. That's the 2 cents from continental Europe.
Thank you, Jan, for that, laying that, giving us that background from the continental Europe perspective. And from what you say, I think it's important to note that while institutional arbitration is to be promoted and is definitely has a lot of advantages, there are advantages of ad hoc arbitration as well, which you just said that if parties really want to just keep it hush and not, choose that. Obviously, ad hoc arbitration has its advantages as well, though we want to move to institutional arbitration for more advantages. That brings me to, I think Charles made an interesting point when he started off, and he said he'll elaborate on that later, where, he was talking about ad hoc arbitration, and then he said, we barristers and retired judges, of course, would like to have somebody like a nanny who can hold our hands, like institutional arbitration. Nanny is, of course, in India, nani means maternal grandmother. Nanny, of course, the helper, but nani is a maternal grandmother is extremely important in families. So institutional arbitration, of course, is extremely useful. But Charles, tell us, you are a very experienced King's Counsel, and you must have seen so much ad hoc and institutional arbitration in your career, several years of practice. And you would have also dealt with applications in court arising from these arbitrations. What do you think are the key advantages or disadvantages of both these methods? And if you can just throw light, it'd be great.
Okay, that's a very good point. I just wanted to pick up briefly before I answer that, just on a couple of the comments made by Ashish and Jan. The arbitral agreement, as everybody knows, but it's fundamental to the modern English approach to the whole of arbitration, I think, that it is seen as a separable agreement. And that's been a big driver. We had a case which actually I was involved in our Supreme Court a couple of years ago called Enker against Chubb, which was a case about an explosion at a Russian power plant that Enker, a big Turkish infrastructure company, had built, and ended up with a split decision 3-2 in the Supreme Court, precisely on this very issue that Ashish mentions, of do you follow the what's called sometimes the matrix law, the law of performance, if you like, the overall law applicable to the relationship, the practical relationship? Or do you go with the arbitral agreement as a self-standing concept, in which case there's pressure, which is ultimately where the majority of the Supreme Court ended up, I'm happy to say, to follow the law of the seat, because the parties see themselves in relation to the arbitration as doing something different from performing the underlying relationship. And indeed, so it is. So that then brings me to your point, Ganesh, which is, how does one approach the question of the court's interaction? And fundamentally, any arbitration process is a partnership between the arbitration, whether it's conducted ad hoc or institutionally, and the courts, which ultimately do have to supervise, do have to recognize, do have to enforce. And so if you need both to work well. And behind all of that, ultimately, there is as I think Jan said, there's a mindset, there's a culture to a very large extent among the legal community, which is what is going to drive forward the efficiency of the arbitral process. In relation to courts, we have in England a sort of specialized and separate track for how any disputes arising, I'm exaggerating slightly, but for the sake of simplicity, how any arbitral disputes will be dealt with. And so the commercial court deals with this, and under the commercial court's operational framework, there is a recognized and defined category of arbitration claims. And all of the judges in the commercial court are specialized and have considerable knowledge of arbitration as practitioners before they become judges. And when you have an arbitration claim and any issue arising out of an arbitration, that gets put into that particular track, and the court will make considerable efforts to ensure that those are dealt with promptly, which is the key point. Because if you have your arbitral framework and you have a nice institutional framework and you have speedy appointments and quality control and all of the other things that we look for, you have interesting point made by Jan, you have this lack of those awkward conversations at the beginning about fees, which I can well understand it injects a difficult note right at the start of the process. So the institution avoids all of that, but you still have to have proper support, timely support, quick support from the court system. If you don't have that, then I'm afraid it doesn't render institutions useless, far from it, but it does mean that some of the good work is liable to be undone. Now, in terms of the framework, the prism through which a court will look at it, as I said in my opening remarks, there's no formal discrimination and there's no difference. There's no rule or case law or anything of that sort which says that ad hoc arbitrations and institutional arbitrations should be treated differently. And many ad hoc arbitrations, as Jan said, the same applies in the UK. We don't really know how many ad hoc arbitrations there are. I mean, from my perspective as a practitioner, I do many more through the institutions. And I think that's just because for most of the cases that I do, the lawyers are familiar at the outset, whether it's in drafting the original contract or in agreeing an arbitration after the fact. People know what they're getting, and they feel that they can advise their clients with a greater degree of certainty as to the process and the prospects and the merits if they're in an institutional framework. And I think that, which is true, and as lawyers, one of the key things where we think we actually make a difference, as opposed to simply depleting our clients' spare cash, is being able to give them some form of greater certainty about the future. And you do have greater certainty in an institutional framework. So there is a legitimate, natural, almost inevitable drive within a sophisticated legal system to push towards institutional arbitration as long as it's not dysfunctional. That when you get into court, if there's a problem in the reference or something of that sort, then I think there is a sort of subtext which you can't quantify. I can't tell you, put a percentage on it or anything of that sort. But if it's operating within the framework of one of the recognized institutions, then I think it gives the judge a degree of comfort, provided, of course, that the rules have been followed. Conversely, if the rules haven't been followed, that's a very useful benchmark. It won't be decisive on its own, but it will give the court a significant steer, which is useful in terms of comparing what's happened with the parties' legitimate expectations. And when you come to I mean, ultimately, of course, the point of any arbitration is to get an enforceable award. And I'd be interested to hear what the others think with their much greater global experience than I have as a sort of essentially, London or common law centric practitioner. But I think there is a benefit in terms of enforcement, that there's just a sort of a franking that's gone on. We also know that I think there are two aspects that make that more precise than just the general cloak of an institution. In some cases, the ICC being an example that I know about, there is an express provision for scrutiny of the award within the institution. Now, the level of that scrutiny, will depend, but nonetheless, it gives an enforcing court one way of getting comfort about what's gone on, and I think allowing it to approach challenges in a realistic spirit. So that's important. LCIA, to take the other main institutional example in London, doesn't have the same process, but what it does have is a sort of culture where the institution monitors what's going on. It's aware of how the arbitrator is dealing with their task. And so, although that may not help in any individual case, but what it does mean is that arbitrators perfectly properly have a degree of pressure on them, an incentive to perform their task in an efficient, transparent, timely manner. And if they don't, then somebody will know about it other than simply the parties to an individual dispute. And so that sort of peer group pressure, if you like, is quite, or a modification of it, I think is also quite important in ensuring that the system works well and gives what it ought to ultimately to clients, unless, of course, you are the sort of client who thinks that you're going to be on the wrong end of a claim, in which case you'd probably be best advised to choose a completely pathological arbitration clause and to put as many spokes into the wheel as you can get away with. But very few people like to admit that at the start of a contract. Rather like a marriage, we go into it protesting our good faith and sincerity, and if it doesn't work out, then it's always somebody else's fault.
Thank you, Charles. I think that's an excellent exposition of the position of you're right. I mean, courts really do not look at whether it's ad hoc or institutional. It's going to be the same thing when the award goes before the court. But one very good point you made, and which from my practice, I feel is extremely useful with institutional arbitration, is that the institutional arbitration provides in its rules for the Secretariat to look at the draft award. Like, for example, the ICC or the SIAC, and now in India, MCIA has it in its rules, and IIAC also provides for that. The extent of looking at it, of course, ICC goes to a very a thorough process, not just clerical errors, but it also looks at some kind of substance where it can point to the tribunal if, for example, the reasoning is missing, and so on and so forth. So when a court probably has an ICC or a SIAC award in front of it, I mean, a judge who is commercially savvy would obviously know that this has been vetted by a qualified secretariat, international secretariat, and that will give some kind of a confidence. And in terms of statistics, I think Ian was mentioning that we do not know how much ad hoc is going. While in India also, we do not know how much ad hoc is really going on the ground. The sheer amount of application that goes to court for appointment of arbitrators under Section 11 of our Act, the default appointing authority is now the court if parties cannot agree. unless if you choose an institution. Looking at that, you can say that predominantly most of the arbitrations in India are indeed ad hoc. And while we speak, today, by the Supreme Court of India, the 7-judge bench of the Supreme Court is hearing a very interesting issue of if an arbitration agreement is not stamped, then there was a judgment which said that it would be per se invalid and the court cannot appoint an arbitrator under Section 11. There's a curative petition that has been filed, and today the hearing has been going on from morning before a 7-judge bench of the Supreme Court. So these are all issues, and definitely, ad hoc arbitration is prevalent. But certainly there are a lot of advantages of institutional arbitration, which you pointed out, Charles, especially in terms of the fees. When it's an ad hoc arbitration, you have to sit and negotiate the fees with the arbitrator, or if they say something, you can't say much. But when it's an institution, especially if an institution has ad valorem fee structure, of course, LCI goes by way of hourly rates, which is also, hourly rates versus ad valorem is also a separate debate in itself. But in addition to fees and other things, there are certain tools in recent years which has been extremely helpful in institutional arbitration. For example, coming to institutional rules which provide for emergency arbitrator provisions. Of course, expedited procedure is also there, but I would like to focus more on emergency arbitrator for the moment, because of we just have about 10 minutes left. So this emergency arbitrator tool has been extremely useful in the Indian context as well, and internationally also. So I'm asking both Ashish and Jan. Ashish, if you could tell me your experience as regards the emergency arbitrator. You can talk from the Singapore as well as the Indian context. And Jan, you could address this from an international angle as to how it's been in Europe, the practice of emergency arbitrator, and how you have found that as a really useful tool in an institutional arbitration scenario. Ashish, you can probably start off.
Sure. Thanks, Ganesh. So emergency arbitrators as a concept is still in a number of jurisdictions quite novel. What I find the most unique thing about emergency arbitrators is that this is one clear example where institutions actually were far ahead of the legislative framework. In fact, they modeled and fashioned the legislative framework. What do I mean by that? Well, take, for example, here in Singapore, we had the SIAC rules, and in 2010, they came up with this emergency arbitrator concept. In fact, I was involved in the first emergency arbitrator proceedings which was pursuant to the SIAC rules at that time in 2010. And at that time, there was no legislative framework, even in Singapore, Singapore being one of the more pro-arbitration hubs even back then. The International Arbitration Act did not actually recognize emergency arbitrators. It took actually an act of parliament to amend the act 2 years after the rules came into force for Singapore to recognize this whole concept. And the reason I bring it up is back then in 2010, when we made the first application, we weren't sure if this was going to even be recognized in Singapore, let alone in some overseas jurisdiction. But what we were confident is that the parties had agreed, so there was party autonomy, they'd agreed to the rules incorporated this particular provision, and we knew that if the other side did not comply, which they were bound to comply, given that the rules expressly stated this, then we had a very good argument back before a tribunal to say that they're not in compliance, and that would have a tremendous prejudicial effect, that this other party was a defaulting party that just didn't actually comply or abide by the tribunal's orders. So on the merits, I thought that was going to help us. Now, along the way, there were other innovative features. We got a supporting court order, and then, there is this perception, rightly or wrongly, but we take advantage of it, that if you get a court order which supports a tribunal or an emergency arbitrator order, if you're in breach, you might be in contempt and you might not be able to come to this jurisdiction to give evidence. So those sort of things were the things that we were looking at. But today, the landscape has changed. And I think a large part of it is because of the ICC and the SIAC and other institutions that thought through this particular provision And now you'll have a number of different legislative acts that actually allow for the recognition. In India, it's been controversial because there was a law commission report that recommended that the Indian Arbitration Act be amended to include within their definition an emergency arbitrator. It did not happen, but it took a decision of the Indian Supreme Court to say, nevertheless, an emergency arbitrator's order would be enforceable under Section 17 of the Indian Arbitration Act. And that's the decision in Amazon versus Future Retail last year by the Indian Supreme Court. So it's done a world of good. And I think a large part of that is the contribution of the institutions that have actually thought through this particular provision.
Thank you, Ashish. I've just got a message from MCIA that their next session is starting at 5, so we really need to wrap up quickly. Of course, the point that Ashish made about the Supreme Court judgment and order of an emergency arbitrator can be enforced under Section 17 is because that arbitration was seated in India, though it was a SIAC arbitration. Of course, if it's given in Singapore, then still you will have to file an application in court and use that as one of the source of evidence to get an interim order based on that. That's of course Ian. I mean, if you could spend 2-3 minutes, giving your experience on this area, it'll be great.
Yeah, sure, Ganesh. Very happy. I fully agree. It's a brilliant idea, organized by institutions. It's an animal of contract, so you don't need the law for it, but you basically need the institutions that set the framework. And the beauty of it is that you can get at the seat of the arbitration by somebody appointed by the institution for that specific procedure, somebody who can take a quick look, who can give a quick decision, and that will just bind both parties. So it's not like, okay, you have to go to different national courts. You have different kinds of types of interim measures available. In the common law world, it's a different standard than we have in the civil law world. And just think about like somebody is calling a bank guarantee. This is notoriously difficult to get stopped before national courts. But the banks, they usually want something in writing, like somebody needs to say, well, this should not be paid out because there are some issues. If you've got an emergency arbitrator, that person can be very helpful. If it comes to an attachment because somebody wants to dissipate assets, that's probably not the right choice. You need the ex parte procedures available by the courts to be acting fast in that context. But if it comes to just finding a solution or resolution for a specific point in time, you need to continue with your construction work. You need to continue delivering. You need to continue allowing people contractual rights and stuff like that. I think it's really, really important to have that remedy, because you are not in a vacuum where you only have the choice to go to national courts and you don't know whether you get it. It's very complicated to find out. You need local counsel, whatever. It's a one-stop shop. And I think it also has the benefit. If you are very early on, everybody gets their heads around one specific issue and you get a quick look from a neutral person. I think that also can help a lot in resolving your dispute without even triggering the need to bring a big arbitration. And that's the question, whether you have that emergency arbitrator independent of an arbitration or whether you are more or less forced to start an arbitration once you initiated the emergency arbitrator. And I would always prefer that there's not a strict link, because you can have that as a kind of own remedy just to do it. But it's very popular. If you look at Sweden, I think they were in the continent the first to introduce it. Then you have the ICC and Singapore, of course. And this is really something that has been accepted by popular demand. And I think it's a good idea.
Thank you, Ian. I think we have unfortunately, I mean, these subtopics that we discussed today are topics in itself, which can be a full-fledged seminar. But 5 o'clock, they're starting another session in person in Bombay, so Mumbai. So thank you so much. I mean, I would have loved to take questions, but we have just a minute left and we need to wrap up. Charles, great to hear your views. Jan, thank you so much for taking out time on a busy day and sharing your thoughts from the European perspective, Charles from the English perspective, and Ashish from both Singapore and Indian perspective. I know you're in Japan at the moment and you need to really go and have your lunch. With that, thank you so much. Thank you, MCI, for this wonderful opportunity. On behalf of IIAC, thank you all. More than 100 people have attended this. that shows the interest, and we'll look forward to seeing you soon. Bye.
Thank you
Bye-bye.
very
Bye.
much. Thank you.
Take care.
Bye-bye.
Thank you, MCIA.